Welcome to We Dissent, the new podcast brought to you by the Freedom from Religion Foundation, American Atheists, and the American Humanist Association. My name is Liz Cavell, and I am an attorney at the Freedom from Religion Foundation.
I'm Rebecca Markert. I am the legal director at the Freedom from Religion Foundation and another one of your co-hosts.
I'm Alison Gill. I'm vice president for legal and policy at American Atheists and another co-host.
And I'm Monica Miller, legal director and senior counsel at the American Humanist Association.
So this is episode 1 of our podcast, We Dissent. And so just to introduce ourselves and what we're doing and what we're talking about, we wanted to have a podcast kind of in the secular legal space, but anyone who works in the secular, atheist, agnostic movement knows that it is a male-dominated space. And so we really wanted to elevate our female voices and talk about some really alarming things happening in the courts and also kind of in the broader legislative, social, political world that are really detrimental to state-church separation, which we all work really hard to preserve in our careers.
And when you look at who's practicing constitutional law like we do, it is also male-dominated. And the legal podcasts that involve constitutional law also very male-dominated. And we wanted to kind of break into both of those spaces. We wanted to raise the voices of women in the atheist agnostic space and in the legal space, in particular constitutional law. I remember when I started at FFRF 13 years ago, many times when I would go to hearings or even just meetings about amicus briefs, I was the only woman in the meeting. And now I'm working with all of these women who are at our sister organizations and are really doing the major work to advance our goals.
It's also worth noting that the courts themselves are fairly male-dominated, especially after the Trump administration. And, they've just been appointing judge after judge who is usually, under Trump, they were white men for the most part, right? And that has a major impact as well, especially when the decisions are more and more impacting people's rights, especially women's rights in the context of abortion and so many other issues. And our name as a podcast is actually an homage to a judge who has spent quite a bit of time standing up for church-state separation and the rights of women.
That's right. So for our first episode, we are going to talk about a Supreme Court case that is pending right now on a knife's edge before our illustrious Supreme Court. It's called Carson v. Makin. And it involves some pretty meaty and just kind of bedrock issues that we work on at all of our organizations, which is public funding going to private religious schools. So we're going to kind of back up, take a bird's eye view, talk about what this case is about and how it started, its path to the Supreme Court, where it stands, what we expect, all the implications, and just kind of try to have a conversation about a really important issue.
This case is one that was described in an article by The Atlantic called the sleeper case of this term. There are a lot of crazy cases going up before the court right now with regard to abortion, gun rights, and things like that. One that people aren't really talking about is Carson v. Makin, and it is a case that's going to have a dramatic effect on the separation of church and state.
Yeah, it's really hard to know where to focus your night terrors with this current Supreme Court and the political environment. There's so many issues that are being threatened, and our negative and fear-based attention is kind of pulled in every direction. So, but we're going to try and pull it in the direction of state-church separation, and that's Carson v. Makin.
We used to have a, major Supreme Court case on civil rights or separation of church and state every, 5 to 10 years. It's become more and more frequent. And now we have 2 or 3 major cases a year on civil rights and church state issues. It just seems like every year there's another major case. And this is certainly the representative one. But last year, what was there? Espinoza, Fulton, the year before that, Trinity. It's just one after another these days, unfortunately.
Right, and that's just in our area of practice.
Religious liberty issues in general have been of increased interest at the U.S. Supreme Court. And like Alison mentioned, they are taking more and more cases. They are constantly adding cases that have religious liberty adjacent type of claims to them. And it's really nerve-wracking to see where we're going. And this is another reason why we wanted to do a podcast like this, because I think when you look at civil rights, the idea of state-church separation is one of the lower ones that people tend to care about. They really kind of have taken it for granted. And now we have all of these cases talking about some aspect of state-church separation, and we have now I think a majority of the justices on the United States Supreme Court who would like to really just bulldoze that wall. At one recent oral argument, Justice Gorch called it the so-called separation of church and state. So this is a big deal, and one of the reasons why we wanted to start these conversations on this podcast, so people understand really what's happening at the court and how their rights are going to be affected.
Yeah. And hopefully, too, through some of these conversations, we can kind of add to the conversation or the understanding of, like, why this is important. Like I said, like, there's so many things on fire. It's hard to really focus on what's important and what's, it's like democracy is ending and women's rights are ending. And it's also like the separation of church and state sounds so, at a remove. But really, once we get talking about some of these issues and what's at stake and what are the sort of like dominoes falling out from some of these decisions, I think we're all kind of hoping to really just like ignite the conversation around why secular government is such a foundational, like, American concept that we should all care about.
Absolutely. In fact, I actually just wrote an article about why Christians should care more about the separation of church and state, and why it's really perverse that we're confronted with federal judges that call the cornerstone of our democracy. I mean, what makes America great, what makes America America, is that we have the separation of church and state. And so when you have the highest judges in the land using air quotes to say so-called separation of church and state, that should be a red flag to everyone, not just atheists, because it's the religious who kind of stand to lose the most when their religion is torn apart and watered down and changed and transformed by government officials and by the U.S. Supreme Court. So I'm hoping through this podcast, we also are reaching our friends and allies that aren't just non-religious, but that care as much about our country and our rights as women and as people who depend upon separation of church and state.
The case we want to talk about today is called Carson versus Makin. And a little background of the case, it arose out of Maine, the state of Maine, where they have a public education system that is a little bit complicated because there are so many rural districts in Maine that don't have enough students to operate their own secondary schools, which is usually a high school. So in those districts, the school district arranges with other public schools or private schools in their area to take its secondary resident students. And in some districts, families can choose a public or private school to send their students to, and the home district will pay their tuition. And that is the way in which the home district provides a public education, as it must do by law, to its high school students when they don't operate their own school. So one of the features of this program for decades has been that the schools receiving this tuition from the state to pay for public school students, the schools have to be non-sectarian, which means they need to offer a secular education that's comparable to what you would get at a public school. And that's to prevent public school funding from being used to pay for religious instruction. And there's not been anything very controversial about that for a very long time in this country. It's been an understood sort of interpretation of the separation of church and state and our Establishment Clause that like public dollars cannot go to fund like religious indoctrination. That's kind of really basic to the Establishment Clause. So in Carson, what happened is two sets of parents who live in a district that doesn't have a public secondary school. So their children were eligible for this state tuition assistance to attend approved schools. So one of those families, the Carsons, sent their child to Bangor Christian. It is a conservative Christian school. And then the other family wanted to send their son to a school called Temple Academy, also a private Christian school, but couldn't because they couldn't get these tuition payments from the state. So these are the parents who filed the lawsuit.
And maybe we want to talk a little bit about these schools in particular, because what they do and what they teach is pretty central to the case as well. And so when you mentioned Bangor Christian, it's a school whose Christian worldview aligns with their sincerely held religious beliefs. So they have a mission of instilling a biblical worldview into their students. They find the Bible to be the final authority on all matters. And what's probably most upsetting to a lot of people is that they refuse to hire anyone in the LGBTQ community. And Temple Academy is very similar. They have a biblically integrated education, and they also refuse to hire LGBTQ. They want to discriminate. There's horrible stories about other things that these schools have done, like expelling students who identify as gay or transgender. Bangor Christian School compels all teachers to affirm that they are born-again Christian and that they are active, tithing members of a Bible-believing church. They don't hire teachers who do not subscribe to that.
We're talking about public funds going to support that mission and those aims, right? That's what this case is about.
Yes, and it's also worth noting that so these schools, their education is also impacted by the education they offer is also impacted by their religion. For example, they don't have a lot of the stuff in the record, but they teach creationism and things like that, right? So it definitely impacts the actual education that students receive as well, with the state funding potentially.
Right. In fifth grade at Bangor Christian, the fifth graders learn that God is the creator of the world. And in ninth grade, they have to agree to refute teachings of Islam and do that by the truth of God's word.
Right. And as is their right to teach in this way, which is what Monica is getting at, these are private Christian schools who, have every right to engage in religious instruction, infuse their entire curriculum with these types of values and beliefs, and who are under Maine law, they are exempt from anti-discrimination laws that would otherwise make it illegal for them to hire on the basis of sex and sexual orientation. Because they're religious schools, they are allowed to operate this way, of course, pursuant to their religious worldview. But what we're talking about in Carson v. Makin is whether or not public school districts in Maine have to pay for students to go here as a replacement for public education in those districts that don't have schools. And so we're talking about all the citizens of Maine, the LGBTQ citizens of Maine, and the minority, the Jews and the Muslims and the non-religious and all the people paying, out of their pockets for students to get their public education at these schools.
These cases don't come out of nowhere either. Like, there's been a movement in this country for a long time to try to sort of whittle away at both public education and channel funding to religious and private education. And, there's been some stops on this, often having to do with no aid clauses in states and their constitutions that prevent money from being channeled, right? But, there's been whittling away of that in the courts, and we just see this progressively more and more cases about trying to shift money from public to private education and opening the doors to make that possible. And this is one of those cases in a long line of those cases.
That's right. And so that's like a good segue into how did this case make its way to the Supreme Court? Because this has been years in the making. So I thought we could kind of back up to 2017 and give a little background here on a case called Trinity Lutheran that was a Supreme Court case decided in 2017 that really kind of shifted the landscape a little bit in a way that made filing this case and kind of moving this football a little bit easier, like Alison was saying. So Trinity Lutheran was a case that involved a state grant program for playground resurfacing. And the plaintiff was a church-run preschool, Trinity Lutheran, that wanted access to these funds. And they were not eligible because of the fact that they were a sectarian school. Same thing, or same kind of situation here, which is that part of their operation involves religious indoctrination and religious instruction. And so the court there decided that the free exercise clause prevents a state from denying an otherwise available funding benefit to a church based on the church's religious status. And so we'll talk a little more about that in a minute, but Trinity Lutheran kind of gave an opening to the families in Carson v. Makin and all of their backers to claim that Maine's system of funding public school education is similar to Trinity Lutheran in that it excludes sectarian schools that teach religion only because they're religious, and that's somehow also violates the free exercise clause.
I think we should talk about the difference of like what Trinity Lutheran, really was about versus kind of where we've gotten to here. I mean, Trinity Lutheran, if I recall, was about like not tan bark, but it was like, a secular benefit that wasn't, funds to go to a teacher. It was like a secular thing. And so even though we all agreed that the outcome was completely wrong, it certainly paved the way for where we've landed. I think there's a huge leap between the facts of those two.
Yeah, you're so right. One thing we talk about all the time when we bemoan the Trinity Lutheran decision is that it really was one of those kind of perfectly plucked cases to garner the sympathy of the justices and also to sort of give a lot of cover fire in the public narrative of like what the case is about and what's fair. So like you said, Monica, it involved a benefit to resurface with like rubberized playground surfacing preschool playgrounds. And the court seemed to somewhat focus on how detached from religious instruction that particular use was.
It's funny, too, the way these things are described in the courts versus how they are in reality, too. Our litigator, Jeff Blackwell, actually grew up in Missouri, right near that church. And he was saying, that playground that they renovated is always locked. Nobody has access to it in the general public. It's only the religious group that actually has access to it. And now they're saying it's a generally available secular benefit. So it's amazing what we hear in the courts versus reality sometimes.
Right. And of course, the problem with funding being that money is fungible. Like money that goes to a preschool that teaches a biblical worldview to 4-year-olds to resurface their playground frees up other money
It's pretty remarkable, though. It flips the religious clauses in the Constitution on their head, right? We went from we can't fund religious activities to, in this case, because of the situation, the state must fund it just because it's a secular benefit and it's a religious organization. So it really is quite remarkable where we ended up here.
That's right. So that happened in 2017. In early 2020, so in between then and 2020 is when Carson v. Makin gets filed in the lower courts. And while that was pending and making its way through the lower courts, the Supreme Court decided Espinosa versus Montana Department of Revenue. And that was in summer of 2020. And there, the court basically decided that a state that is subsidizing private education in some way cannot exclude a school from that funding just because of the school's, again, religious status. So it kind of took Trinity Lutheran, but then blasted it out of the super sympathetic playground resurfacing ticket item and into what in that case was scholarships for private sectarian education that could be written off.
What amazes me about this case, in some ways, is the standing aspects of it, I have to say. Just because it's amazing that the court goes so out of their way to take these cherry-pick cases that they want. The standing issues here are remarkable because, I'm sure Liz will go into a moment, but this case, the program had already been struck down, and the court really reached to sort of create a new program out of whole cloth. It's unclear who benefits or what the benefits are going to, and yet the court is really trying to get access to it. And we're seeing this in other places when it comes to religious cases as well. The court is really going out of their way to get these cases where they want them.
Standing is basically this threshold question that federal courts are supposed to answer before they can even really hear a case, which is, it kind of boils down to, is there a concrete injury here that we can redress by making a ruling in this case? And a lot of times, the facts on the ground are constantly changing and evolving in ways that make the answer to that question no. And Alison's talking about the Espinosa case in 2020, where basically the whole Montana program that was the funding program at issue, that was funding private sectarian school or private school scholarships, was, I think it was suspended or it was defunct.
It was struck down, if I recall, by the Montana Supreme Court. So there was nothing left for the court to strike, and they would have to resurrect and recreate the legislation for the Supreme Court to strike it down. So it was technically moot.
Right. So normally you would expect the federal courts in our kind of system of review to not take a case where the injury and the conflict is not live anymore. So in other words, their ruling is just kind of like they really want to speak on this issue, but it doesn't change things on the ground.
Right.
So that's just bizarre, especially for all of us who have had our cases thrown out for lack of standing repeatedly.
Right. I was going to say that it's so interesting because re-listening to the oral arguments of the case that we're going to discuss, the Maine case today, the Carson case, and listening to them talk about standing, it's like they go out of their way to preserve standing in these cases with Christian plaintiffs and where there isn't. And then when there's an atheist plaintiff, like the Michael Newdout case challenging under God in the pledge, where they create, I think Justice Rehnquist even, in his dissent concurrence of that wildly, dicta decision, had said, this is a ticket for one day rule that you've created to box out an atheist plaintiff, because the liberal wing at that time was concerned that the conservatives would just say that God is allowed. But the point being is that our plaintiffs, we have to go through hoops and bounds when we have such clear standing, and when there's nothing left to legislate and it's completely moot, and the Supreme Court still takes it.
And that's really like the joke that has arisen from a lot of these terms recently, is just like, oh, they took that case. Why? There's no reason to actually take that case. Oh, but the plaintiffs are Christian, so that's probably why, and they're going to do something horrible. We don't really, we laugh about it, but we shouldn't. but it's definitely true. I mean, if it's a Christian fighting for a right, they're going to take it, they're going to give them that right. And all other religious minorities or non-believers are not going to get those same privileges.
Yeah, it's so cynical, but it's really true. If you court watch, it is not been traditionally very easy to get the Supreme Court to review your appeal. There's an astronomically small percentage of petitions that they accept for review. And so when they take a case, it's really because they want to. There's no other kind of rhyme or reason. And especially as time goes on, standing is kind of be damned if they really want to address an issue.
And in cases like, this and like Fulton, for example, which is another case I'm sure we'll eventually talk about, the watchers we're all thinking, oh, well, they're definitely going to side for the Christians. The question is, how bad is it going to be? How much are they going to twist the law? How much are they going to rip apart precedent to get there? Yeah. And it's a really bad place to be, but that's what we're seeing in the courts over and over again. How bad is it really going to be? It's not a question that the Christians are going to win. The question is, how badly is it going to be for our side, which is awful.
Yeah, well, that's a great segue back to Carson v. Makin. So what we were just last talking about is this Espinosa decision. So that came down in the summer of 2020, basically just expanding that Trinity Lutheran decision into a space that just involves funding to private religious schools. And the fact that actually it violates the Constitution not to give funding to religious schools. And then in this case, the Carson case, it's in the First Circuit Court of Appeals, which has jurisdiction over Maine. And it was in October of 2020 where the First Circuit Court of Appeals decided against the parents' claims and held, as is appropriate under current case law, that this Maine program doesn't violate the free exercise clause, and that this program is not like Espinosa and it's not like Trinity Lutheran because Maine does not have a bar on schools getting this funding based on their religious status, but it has to do with whether or not schools are going to engage in religious instruction, religious curriculum, and all of the things that Rebecca was talking about that are pervasive religious promotion throughout these schools' policies. So, schools are being excluded from receiving public money based on whether or not the funds are going to be put to a religious use. Because, of course, there are some religious schools that receive funding under this program, but they offer a comparable secular education to what students would receive in Maine public schools.
This religious status versus religious use distinction was sort of laid out in Trinity Lutheran. That's where they first discussed it. And they didn't really go into, they didn't explicitly say that, religious use can be restricted. It was more like, we're talking about status. We're not going to say anything about religious use. And some justices have already started to criticize that breakdown quite a lot, actually. So the question is, what we're concerned about here, are they going to basically destroy that line altogether in this case versus religious use of money versus religious, discriminating based on religious status?
That's right. And the parents, the plaintiffs in this case are arguing exactly that, which is that this status and use distinction is useless. It should be overruled. And that this type of exclusion from funding should be unconstitutional regardless of what the money is being put to, or what use the money is being put to.
Yeah, and I think we have to sort of stand back and remember kind of like what discrimination means in these contexts, and sort of standing back and understanding the interplay between the Establishment Clause of the First Amendment and the Free Exercise Clause of the First Amendment. The Establishment Clause, as we know, comes first. And that's what gives us the separation of church and state. And there's the Free Exercise Clause, which says, the government can't burden or infringe upon your religion. And the court has said that there's this sort of play between the joints where the government can create a program, but it doesn't have to, be an all-comers program if it's secular. But now you've got these religious groups saying it's religious discrimination to exclude us. And yes, in a sense, it is religious discrimination. I think Justice Breyer says this in the oral argument, but it's allowed because of the Establishment Clause. And so I think just standing back and understanding the posture of some of these states, you have some states that want to go out of their way to create tuition programs to fund religious schools. Here in Maine, we have a state that actually doesn't want to do that. They want to provide secular education. And there's some areas in this kind of remote state where they don't have, a public school, and they're saying, let us find the closest analog to a public school and support that. But they're not saying we want to support religious education. And so this is so unprecedented and alarming from the standpoint of what they're demanding. They're saying we have a right for the government to pay for our religious instruction. And that contravenes the core foundation of of what it means to violate the separation of church and state, to give money for religious instruction. So I think, when we talk about these minor distinctions between religious use and this, it's like we have to remember the bigger picture too, which is what they're asking is really at the core of what the Constitution prohibits.
Right. That's such a good point. Like Rebecca said at the top of the episode, this is kind of like the sleeper case that not a lot of people are really worried about or talking about. But I do think in one space where there is a lot of just kind of fear and pushback is just the attack on our public schools. So, there is a real sort of not even undercurrent to this case that is this direct attack on the fact that our public school system provides this secular education. And there's a lot to talk about here in terms of what we've watched happen over the past year with critical race theory and all the attacks on public school curriculum and local control and how we should take that away from schools, as Monica is correctly identifying, is the Supreme Court is poised to basically say the state of Maine has to view a public education as including this incredibly conservative Christian infused, type of education and curriculum. And the fact that it doesn't is discrimination. And it's just this battle between secular education and secularism and what we teach and what we think of as a well-rounded secular education for our kids, public education, an appropriate public education, versus what, a shrinking majority of people would want their kids' education to involve.
I mean, in effect, it's saying that the state does not have a right to offer a compelling interest in offering a secular public education, too, right, which has incredible, repercussions down the line. If that's true, then what about, charter schools? Does it have to start accepting religious charter schools if we have other types of charter schools? And if you have to offer, basically, what about if there's what's the compelling interest in separating, religion from public education in the first place? So, I mean, it potentially opens up further doors as well.
Let's discuss what happened at oral arguments. So just in the timeline of events of this case, the Supreme Court agreed to hear this appeal in the summer of 2021. So that just happened. And obviously it's a bad sign because the First Circuit, as far as we and many others are concerned, kind of got this decision right on. And now the Supreme Court is selecting it from a massive pile of petitions to address this upcoming term. So that's a bad sign. But the first signaling on this happened in December of 2021, just last month, when oral arguments were heard in front of the Supreme Court. So let's kind of talk about what we heard, what it signaled, who said what the arguments were.
Well, I think that the the side that the petitioners, Carson, are trying to lay out is that basically under a prior case law, it says that private schools, school choice, having school vouchers that go to the individual parents or, to go to private religious schools is just fine. So that's not prohibited by the Establishment Clause under a case called Zellman. And that, notably, that case does depend on the parent making a genuine independent choice. So that was okay. But one of the major problems is we've seen this sort of reliance on a previous older case called Widmar v. Vincent that basically says that anything that, trying to go broader than the Establishment Clause, trying to protect rights broader than the Establishment Clause is not a compelling interest. And so under that sort of guideline, if something is not constitutional, something is not required by the Establishment Clause, it becomes almost mandatory. Like Monica was saying earlier, there's less and less room between the two clauses.
I want to know if you guys were got any signals on whether or not this particular court cares about standing. We talked a little earlier about the standing in this case, and I just wanted to mention it's these schools of choice of these particular parents, the ones that we talked about specifically, they don't actually accept the Maine funds. They don't want to accept the Maine funds because they don't want any restrictions on their conduct, their hiring practices, their policies. And they know that that would be something that would be scrutinized if they were going to accept state funds, as it should. So technically, these parents couldn't use state funds for these schools if they wanted to. They don't. The schools themselves do not participate in the program. So it did come up at oral argument, but I kind of wondered how much of it was lip service and how much of it anyone really cares about on the court.
I felt, my knee-jerk reaction was that this is such a double standard, because if you substituted an atheist plaintiff, we wouldn't even be in this court. But I think they're going to bypass it. And the only silver not bypass it. And if there is a split within the conservative wing, that maybe will do it. But I don't think they're going to kick them out on standing. I just don't think they would take the case and then do that. So then all I can, the only silver lining I can glean is that maybe we can use this to bolster our standing when it comes to some pushback in Establishment Clause cases, later down the road. But I don't see them kicking this case out on standing.
Well, and I think really what happened at oral arguments and in the briefing is that they started talking more about the opportunity to have these funds, not necessarily that they would have access to these funds, but are they being denied the opportunity to have these funds? I also want to just jump back and point out that one of the sets of parents are already sending their children to that Christian academy. They're not denied that education. They're actually paying for it. They just want the state to pay for it. And then the Nelsons, the second set of parents, they would like to, but they need the money from the state in order to send them to Temple Academy.
Except Temple Academy, as I think Monica just said, they're not going to take the money.
Right.
Correct. Both schools that we're talking about do not agree to take this money because, of course, as the program has been operating non-controversially for decades, they don't want to accept any limits on how they operate as a Christian school.
And that's the proper role of church-state separation. We're friends. Our groups are friends with the Baptist Joint Committee or Commission. I forget the C, but they are a very, they're religious, a Baptist group, but they also support separation of church and state, and they support all of our work very well. And they say they kind of want to shake their religious allies and say, there's strings attached when you take money. Why do you guys want money so badly? This money, it is going to warp and change your religion. There's no free lunch. And I think that those Maine schools that are refusing the funds, they're, from our standpoint, awful schools that are, have really bad ideas. But that is one area where they think they're pretty smart.
I think that you've really hit upon a major point there, and that's that the modern project of the conservative law justices is to contort the law so that they can have their cake and eat it too, so that they can get money and also get rid of all consequences for having government money.
And
right?
It's just not going to work, though. I mean, here we see the Satanists barging in at every opportunity, and I'll call them and tell them, hey, they just said that the Bladensburg Cross is open for everyone, and it represents atheists and Muslims alike. And what did they do? They showed up and they rebranded the Bladensburg Cross, the Satanic Bladensburg Cross, and they had a big ceremony, and the Christians were outraged. And the Supreme Court only has so much control, and they can try to set it up where they give the Christians everything and they kick the atheists out. But when you set up these rules that apply to everyone, and the country is getting more diverse, whether the Supreme Court likes it or not, and younger folks are moving away from religion and church, they have no control over that. And I think what we're seeing in this increase in taking these cases is the Supreme Court trying to grab that control. And we need to get the schools, we need to like indoctrinate the kids. They're getting away from religion. So I think it's almost like I try to stand back and not like let myself get so emotional and frazzled by all of this, and be like, this is maybe a sign that we are progressing as a society, and the Supreme Court is freaking out and trying to take the reins.
It's so true, but it's also like, then the part of me that is emotional and frazzled is like, well, they're doing it. It's like Alison said, it's been the project of the past like couple decades, and they're doing it in time when they still have the institutional advantage. Because what's going on in Maine is and elsewhere, it's a microcosm. And obviously this case, the Supreme Court ruling is going to be the law of the land everywhere. Right. This is happening at a time where the vast majority of any of the private schools we're talking about that would be implicated by a decision are Christian. And many of them are these conservative Christian academy type schools. We're not living in that pluralistic future yet where, there's just as many, takers and comers from minority religions as conservative Christian religious schools. So the institutional advantage is still so baked in that like the windfall of gains from these just crazy decisions undoing all of our secular norms is going to fall to the most conservative Christian organizations that are already kind of advantaged in the system. And then what does that mean, Yeah,
no, you're totally right. I think one thing I would point out is, can't Maine, after all of this, just say, you know what, then we're not even going to give funds to these private secular schools. We're going to take all that money and just really make a more robust public school system.
They could. And they could also say, we're going to actually put lines on this. We're going to say, okay, we're not going to give the money to any school that discriminates. Yeah. We're only going to give the money to a school that has classes that are in line with standard public school classes, like biology that teaches only real biology and not creationism, stuff like that. They could absolutely do that.
And I think that's sort of my point, is at least within the states, because you're right that like geographically there's no Satanist school, there's no probably no Muslim school.
You can bet if there's one minority religious school in Maine, it was trotted out by the plaintiff's attorney to show how ecumenical their whole deal is. But what we all know, because our eyes are open and we can look around, is that we're still living in a world where the majority of the people are Christian, and the institutional just buildup of that is not going to be undone. Changing demographics are awesome and encouraging, but it's not going to be undone in time for this to save us from this Supreme Court.
And I just think that all of the solutions that we've brought up here about, putting up rules that they can't discriminate, they can't do this, they can't do that, just harkens back to what Alison was saying before. They want their cake in there and eat it too. So we've seen these trends coming from the U.S. Supreme Court where these religious organizations are going to the court saying we need not to be discriminated against, but at the same time, we want all sorts of exemptions so that we don't have to play by those same rules. So even when you say, hey, they're getting funding, and with that funding comes all sorts of restrictions and regulations. I don't see that being necessarily true in this day and age, because they're seeking exemptions and they're going to court over them and they're getting them. And that's what's most frazzling about this and most upsetting, when inevitably this court decides that Maine's system is unconstitutional and taxpayers are going to be forced to fund religious education for people.
And this is sort of reflected in the oral arguments as well, where basically they make the argument repeatedly that this is, the justices seem to be making the argument repeatedly that this has a disparate impact on certain religions compared to others, right? Which should not matter, right? You're allowed to have neutral rules even if they affect different religions differently. I mean, that is always going to be the case, actually. Almost any law will affect different religions differently. But here it seems to be a really big deal that it affects certain religions and not others. And then if we think about something like a non-discrimination law, guess what? That's going to affect certain religions more differently than others too. So that's very worrying to me.
I actually took note of that as well. And I thought it was so interesting that in the town of Greece context, in the legislative prayer context, when we saw an overabundance of Christian prayers being delivered at this city council meeting, and we were saying that promotes Christianity. Well, in the flip side, when we bring the Establishment Clause case, they go, oh, it's mere demographics. That's not an intentional discrimination. That's not preferring Christianity. That's just an accident of geography. But then when it's on the other side, they're like, it's the exact opposite. It's like, well, this is disparate impact and discrimination. Like, it's not discrimination against atheists to have abundance of Christian prayers being said every city council meeting, but it's discrimination.
Right. And it's another like coded attack on just like public education and all of us woke people who like secularism, like it's this idea, it's like, well, did you ever notice it's only the conservative Christians who don't qualify as comparable secular education to, or like, oh, why is it always us that are the only ones that don't abide by anti-discrimination laws? Like this has such a disparate impact on us. Well, yeah, because liberal Christian schools are trying to give a well-rounded public comparable education to their students, and you are an indoctrination factory. You insist on discriminating.
That's why,
as is your right, but like
that's what I was thinking. It's like a race to the bottom. When they were asking that line of inquiry, it was Alito, I think that was, of course, probably, but like I almost remember him really hitting hard on that, like, and I'm thinking this. You're proud that you are disparately impacted by the general laws of applicability that say you can't discriminate, that you have to teach a proper education. Like, I just don't.
Right. It's this total inversion of like persecution.
Yes.
And who's persecuted by what, and what the religion clauses are meant to protect versus meant to, inflict.
They're weaponizing the free person.
Another way they're doing that is by sort of using mismatched or conflated terms for the word secular. For example, they're portraying public schools, which are religiously neutral, as being somehow anti-religious because they're secular. Like secular as in secular means anti-religious as opposed to just meaning not religious or religiously neutral. And so we see that in the context here, like, okay, well, you're funding public schools, but those are actually anti-religious, and therefore that's discriminatory. But that's not the case. Of course, they're religiously neutral. And I think Makin, the government side, made the point that if the government can't, under this rule, fund anti-religious schools as well, as if those actually existed, but they could not fund, like, I don't know, atheist-centric schools, I guess, either, in the same way they can't fund Christian-centric, Christian-infused schools. So I thought that was actually what we focused our amicus brief about American atheists. You
focused on that distinction?
The meaning of the secular distinction and how it's sort of used and misused and conflated by both opponents and by justices sometimes to sort of convey these dual meanings at the same time in ways that undermine religious neutrality.
It's so true. I mean, that's how they kind of dog whistle to this culture war that is, undergirding this whole movement, which is, secular is somehow anti whatever conservative and what are conflated as like conservative Christian values.
Answered a question to that effect about whether, if there was a school that was promoting Unitarianism or it was a Unitarian school. And I think it was Alito that basically like described what a public school is, but he used the word Unitarian, and the lawyer was like, well, if it's a public school that teaches, civics and good manners and being kind to one another, like basically what the guy was saying, Unitarian, he's like, well, that's allowed. But if it's, anti, and Justice Alito was like, well, it sounds like that's consistent with teaching, Unitarian and this and that. And again, it goes back to that line of cases. I feel like there was a bunch of them in our Establishment Clause cases where they say that that secularism is not the same as anti-religion, and that to say that removing a cross is hostile to religion is not. It's restoring the government to a place of neutrality. And so here again, we're looking at Christians demanding public funds, like.
Right. It's like, just because your religious belief tells you to, like, hate gay people doesn't mean that if I don't hate gay people, that's my religious belief. Right. You know what I mean? It's like...
like, murder is wrong. It does not mean that that's a religious belief just because religion says murder is wrong, right?
Right.
That's exactly
and so the lawyer basically was saying, like, yeah, if it was like a pro-humanist school, if it was like the Unitarian Universalist school, they said off the bat, we'd probably just exclude them because it wouldn't match up with, or however they answered it. It's like if it was against religion, but if it's a public school, then it's allowed. Like, they were saying that these were not tricky decisions. They weren't that gray of an area because most of the schools were either so clearly a religious school or they were so clearly a secular school.
Of course, as Justice Alito well knows.
Exactly.
But when you listen to these oral arguments, how infuriating is it that these are supposed to be our 9 premier, legal American jurists, and it's all this, what you're describing, Monica. It's just this kind of wordplay that's meant to just kind of argue for one side and give these analogies and hypotheticals that we all know are not tethered to the reality of the situation or relevant to the legal question that's before the court. And it's really, really infuriating to listen to these arguments. It is disheartening. Well, anything good come out of the oral arguments?
Well, the government did a good job. I mean, the best they can at the Supreme Court. They made it clear we're talking about the benefit here is a secular public education, right? That's what we're talking about. That's the benefit. And so I guess the question is the Supreme Court going to let the government define that as an available benefit? And if it doesn't, then we lose. And if they do, then separate church and state wins.
Right.
But that has real repercussions.
Right. Justice Sotomayor kept, I think, kind of keeping it alive in the oral arguments. And I agree, Alison, the government attorneys did a good job kind of keeping it front and center, which is like the thing that the plaintiffs are entitled to here in the first place under the program is a public high school education for their kids, like just like the rest of us, like nothing more, nothing less.
Right.
And so it's so perverse to get to the outcome that we all know is coming. Which is, no, you're actually violating their rights by not paying for their conservative Christian high school education.
Right.
So how is the court going to get there?
That's the question. And I think it's going to obviously be an extension of, all the cases we discussed at the beginning of this, Trinity Lutheran. It's scary to think, I don't know if there's any sort of case that is going to be abrogated or overruled. In a way, it kind of abrogates and overrules the notion that there's a separation of church and state, because if not giving government funds to a Christian organization, a Christian school for Christian indoctrination, like, you know what I'm saying? Like, it's hard to square that with like removing a Ten Commandments monument.
It's so foundational to like what that wall of separation still stands for. But I'm wondering, like, okay, so in the weeds a tiny bit, do we think this is the end of like status versus use for funding?
I don't think they need to go there. They might. It depends on, we have new justices that have not seen rule on that before, so it's hard to predict. But they can just say, well, this is just like Espinoza. We don't have to. Yeah, it's status, really, even though you pretend it's not. It's actually status, and just not go there and try to glide over the difference in the two policies. I think we might end up with that, especially because we seem like Justice Barrett seems to not be sort of sticking her neck out yet on these things, trying to play it safe. So I think we might end up there.
I agree with that. I think that they're just going to liken it to other school choice programs across the country. And this is just another version of those programs that we've already held need to be given government funds. Even though I think Justice Kagan, during oral arguments, explained this is actually a really unique program. It is not like those other school choice programs. I mean, the fact, it was boggling to me to find out that Maine didn't have some secondary schools. I just didn't know that like existed in the world. But they're going to ignore the unique status of this program and just liken it to all other school choice programs and find that it is a violation of the parents' rights and that the program needs to be revised.
Yeah, I do agree with that. I think that the concern that I have is with the precedent that it sets for all the other states and what will happen when, like Maine might decide, okay, we can't do this, or we'll restructure this so we don't have to give our funds to these Christian groups. But what about Alabama? Like, is this a green light for states to now create and run away with programs much more egregious with this because they know, that they can just directly funnel money now? Like, what, the posture of this is a state that didn't want to do this. What about all the states that do want to do this?
Well, I'm going to just create a little differentiation there. They're not directly funneling money. They are using the medium of the parental choice, right? So that is different. Now, the question is, what effect is that going to have in the long run? And I would say Alabama can already do this under Espinoza, we were just talking about. So it's kind of, I'm not sure what the implication is going to be there. I would say that, what we could hope for success on our side would be if, we look at Zellman or something like this, which says that there has to be independent, genuine choice. And, there's, so basically that's the only reason that these school choice programs are constitutional under the Establishment Clause is because of this independent, genuine choice. If, somehow magically, this was the ruling that I'd like to see, they say, okay, well, in this instance, it's not constitutional. It violates the Establishment Clause because in these rural communities, there's no public schools. There's no independent choices. So therefore, it's not constitutional to fund them. And therefore, the state has to win. It cannot offer these other types of options. So anyway, just a thought.
Allison, wake up.
I know, right?
I'm swinging in here with like the cynical point that doesn't need to be made, which is this is just it's counting heads on this kind of movement towards flipping the free exercise clause as the dominant kind of way in which like states can violate or abrogate their obligations under the Constitution, and elevating the rights of Christians, people in the majority religion, by just sort of confusing and conflating all of these arguments. So I think we're going to see like a lot of discussion about discrimination on the part of the state of Maine for refusing to fund conservative schools under their public school program. And then, a bunch of concurrences that are, just to the sides of that. And probably this will be 6-3.
6-3?
Yeah, I think so too.
So if this is just an extension of Espinoza and a little bit more of the same, even though oral arguments, Justice Kagan and the advocates tried to really draw out that this is a really unique cabined kind of program. What's the fallout? Like, why is this so bad if it's just kind of more of the same, what we've seen in Espinoza? What are we worried about?
Well, although they might sort of elide the status use distinction, it actually still exists here. We are talking about usage of the funds, right? Even though the court might not delve into that. And therefore, you're weakening it. Like how they talk about it is going to weaken that distinction, even if they don't discuss it much, So, and we should discuss a worst case scenario too. What happens if they do sort of break that down directly, or if it's broken down over time? What does that mean? But I think that's going to be the fallout here, either in the short or long term.
Yeah, I think it's so important to like how bad this is for just public education, and that's something that's like really been near and dear to us, at least Rebecca and I, in our work at the Freedom from Religion Foundation. And I think all four of us, like, we work a lot on keeping the public schools religiously neutral, and that is just so at the heart of what the Establishment Clause exists to do, because like our public schools are our biggest state machinery, and our kids are our most impressionable people, and so their right to a public education that's well-rounded and that's religiously neutral has always been so jealously guarded by the courts under the Establishment Clause. And now, in this broader kind of culture war that we were talking about, that kind of aims to like really pit public education against whatever this is, I do feel like that really is kind of the most tragic place that this case can do a lot of damage that hadn't been done in past religion cases.
Yeah, and we also have to think of all the lower court decisions that are pending, that we all have pending in lower federal courts. On any Establishment Clause issue, anything the Supreme Court says, anything in a concurrence, our opponents can take and extrapolate, and all it takes is a Trump judge or a judge that needs a hook to hang their hat on, and it doesn't even have to be factually correct. Like, Alito makes up stuff. Like, he made up stuff in that case. Like, and so it's like they'll get away with a lot. And what I'm concerned with is like what kind of dicta Amy might throw into her concurrence, or whatever kind of mess of decisions we get. What they will say about school prayer, what they'll say about like the Santa Fe and Lee cases. We know that there's this school prayer case now in the pipeline. What are the conservative judges going to say to set the stage to tear that apart? I think the public school education stuff, we'll see the negative effects maybe down the road. One little tiny, maybe not pushback, but another backdrop thing to consider is that in some of the Supreme Court's ministerial exception cases, the Supreme Court was ruling against religious teachers in a way. Like the court, when it said, what was the one? Hosanna Tabor, where Hosanna Tabor and the recent ones, but where the Supreme Court,
Our Lady of Guadalupe,
where they say that basically that these religious schools are exempt from discrimination laws, the ADA, and that kind of thing. And who loses in those cases? They're not atheists, they're religious employers. And if I was a religious employer in Los Angeles and I just learned that the Supreme Court said my school can fire me for having breast cancer because I'm a teacher, I'm going to go maybe look for a job at a public school. So there might be some weird interplay with some of the other Supreme Court's decisions that seem to favor Christians, but they actually favor Christian employers or the leadership and not the actual people. I think those forces are not strong enough to counter that. But it's something I've been thinking about with the public school context and how the court is trying to create that have your cake and eat it too. But there's these kind of reverberations.
That's a really good point, Monica. And I think it does have an impact on the individual teacher or doctor, or whoever has to interact with these institutions. And they might make these decisions themselves. They don't want to be forced down this road, right? Also, you're talking about the attacks on public education. You reminded me that there were, I think, either one or two amicus briefs on the other side supporting, Carson, that had said basically that you cannot offer public education. It's unconstitutional, right? right? So that you can see what road they're trying to head down.
Yeah.
That public education is unconstitutional because it's inherently discriminatory towards religion.
Yep.
So just think about that for a second. Something that's existed for, well over 100 years in this country and more is not constitutional because it discriminates against religion, because that's where we're headed.
You kind of see that writing on the wall in the parallel track of like, you can't teach like, kindness and racism and that's
history.
Exactly. Like these are the things that are kind of like operating on sort of a social track but then also this religious track. But it's always been kind of the gloss or the Trojan horse that lets the Supreme Court kind of opine in this way when you call it a religious, or when you kind of cloak it as like, this is a sincerely held religious belief of these parents in these schools. So we're going to talk about discriminating against, LGBTQ students as though it's like,
that's their religion. Like it's
right. And so then the opposite of that, like we were saying before, it's like this perversion of like, well, just because that's your religious belief doesn't mean that like,
the opposite is also a religious belief.
Right, that public schools are also somehow unconstitutional. It's just this total just perversion of the whole like system. And the Supreme Court, some of these like really activist conservative justices are just giving, oxygen to that fire. And it's scary.
Yeah, it is. It is scary. I mean, I think all of this I think what scares me about this case, just like some of the other ones, is like how they kind of did fly under the radar. And, I think it kind of is part and parcel of the reason why we're doing this podcast is I've been doing this case law for about 10 years now. I know Rebecca's been doing it longer and Liz, and, it's like, we want others to understand and not share our misery, but like kind of wake up, because the issues kind of seem nuanced, or maybe they're not as sexy or big as, Roe versus Wade, but they're so cornerstone to like what our country is about. And they have very specific and real effects right away, in public schools and with employment issues. Even though these cases sort of sneak under the radar, they're extremely important.
If I can just add to that, we did a national survey of about 34,000 non-religious people across the country to understand what issues are important to them, and maintaining secular, non-religious public education was a number one concern out of everything, right? For the 34,000 non-religious people. So it's really important to our community. People really do care, and I think if we can get the word out about this, it will make a difference in the long run.
And I mean, think about how fired up all people across all demographics, not just, non-religious groups, but just parents and people who are related to little kids, like public schools, how they operate, that they're open, that they're a resource for our kids, like just in the past 2 years and what we've all been through in terms of like how essential public schools being open, operational, and public and accessible to everyone and to all of our kids. And a case that, like Carson, that's going to take just power out of the kind of public school project by saying that, the Establishment Clause doesn't mean that much in the public schools, and really all we should care about is like, funding religion equally. It's just kind of damaging the whole project. And if people can sort of like see those connections, I think that's really good. So what do we think? A decision this summer on this case, right?
Yeah.
Sadly.
Indeed.
So we'll know by this summer what happens in this case. And hopefully at that time, we can give an update. And is there any final thoughts anybody wants to say about Carson v. Makin or about the podcast? Or should we end on a high note? Is there a high note? There is no high note. Low notes.
I missed it.
Let's end on a low note. That can be our thing.
Okay, my high note is demographic victory. We're winning in demographics. Give it time. Okay.
Give it time.
I think the
like
other high
years.
note is that we will be back with another episode to talk about these issues again. Our next episode, we're hoping to discuss the Christian flag case in Boston, where we will examine the free exercise and free speech claims of those petitioners who want to raise the Christian flag at Boston City Hall. We Dissent is a joint production of the Freedom From Religion Foundation, American Atheists, and the American Humanist Association. It is hosted by attorneys Liz Cavell, Alison Gill, Monica Miller, and me, Rebecca Markert. Other production support comes from James Fetaplace and Greta Martins. Audio engineering is provided by Audio for the Arts based in Madison, Wisconsin. Thanks for listening.